State of Cannabis.
This is the State of Cannabis News Digest, a roundup of this week's key developments in the cannabis industry.
Good morning, and welcome to this week's Cannabis News Briefing, released every Saturday at 9 a.m. Across the United States, cannabis policy is moving in sharply different directions. Texas lawmakers are preparing another fight over hemp-derived THC, while Virginia businesses warn that changing rules could leave farmers and retailers stranded before the state's recreational market begins. Illinois, meanwhile, is expanding possession limits, medical access, and dispensary services. For medical cannabis patients, legal access does not always mean affordable access. Kentucky's young market is drawing complaints over steep prices, while New Hampshire's governor has blocked a cultivation proposal intended to reduce costs. Cannabis is also moving deeper into election politics. Kansas candidates are debating legalization, tax revenue, and patient access. In Massachusetts, voters may be asked whether to roll back recreational sales and home cultivation nearly a decade after legalization. And the legal conflicts extend beyond elections. A Pennsylvania lawsuit connects an old marijuana conviction with modern gun rights. Wyoming is refusing to follow a federal cannabis rescheduling decision. In Washington, the banking industry is again asking Congress to protect financial institutions that serve state legal cannabis businesses. Stay with us for the details and for what these developments could mean for patients, consumers, businesses, and voters. This broadcast uses AI-generated voices to help make the program clearer, more varied, and more dynamic. The reporting, writing, and editorial decisions are guided by our news team. The voices allow us to present the program with greater range, pace, and personality. New listeners can subscribe now to receive each Saturday morning edition. Existing subscribers can support the program by hitting the like button.
And now here is the deeper look at the key events in the cannabis world this week.
Texas is heading toward another political fight over hemp-derived THC products. The State Senate Committee on Health and Human Services held a hearing Tuesday to gather information for possible future legislation. No vote was taken, but several Republican senators and invited witnesses made clear that they want stronger action, including the possibility of a statewide ban. State Senator Charles Perry of Lubbock said he plans to file another bill banning consumable hemp products. Perry sponsored a similar proposal that passed the legislature during its previous session. Governor Greg Abbott vetoed that measure and instead directed state regulators to tighten their oversight of the hemp industry. Those new regulations took effect on March 31st. They required child-resistant packaging, updated labels, product testing, detailed bookkeeping, higher licensing fees, and a minimum purchase age of 21. Laboratories must also measure the total amount of THC in a product. Products exceeding the legal threshold of 0.3% are considered non-compliant. That requirement has already affected products including THCA flower and pre-rolled joints. At the Senate hearing, lawmakers focused heavily on public health concerns. State Senator Lois Kolkhorst cited Texas data showing that over 1,500 children tested positive for THC at birth during fiscal year 2024. That number rose to nearly 1,900 in year 2025. Dr. Dominic Lucia of the Texas Medical Association said emergency department visits involving THC have increased over several years. Other witnesses offered a more qualified assessment. Catherine Neal Harris of Rice University's Baker Institute said THC may increase the risk of psychosis for people who are already predisposed to those conditions. She said that is different from concluding that THC causes psychosis in otherwise healthy people. Harris also said Texas needs affordable treatment options for people with substance use disorders. The hemp industry is arguing for regulation rather than prohibition. Industry supporters describe the Texas market as a $10 billion sector, employing approximately 50,000 workers. With lawmakers preparing another attempt at a ban, both sides are now getting ready for the next legislative session.
Virginia is moving toward a legal recreational cannabis market, but hemp farmers and small business owners say the transition may leave them caught between two regulatory systems. Virginia's legal adult-use cannabis market is expected to take effect in July 2027 under the final state budget. Federal changes to the definition of legal hemp are scheduled for this November. Hemp operators say those changes could make many of their existing products illegal months before Virginia's recreational market opens. Barbara Biddle, who operates District Hemp Botanicals, has already given notice that she will close her Leesburg store. Her businesses sell hemp-infused products, including creams, bath salts, beverages, and gummies containing CBD or THC. Biddle said the legal uncertainty was not the only reason for closing the Leesburg location, but it contributed to the decision. Caroline County farmer Graham Redfern is also concerned about the transition. Redfern said hemp naturally produces cannabinoids as it matures. In his view, it is difficult to build a viable industrial hemp business if products made from mature plants are treated as marijuana. He said businesses like his need either a grace period or another pathway that would allow them to survive until the recreational cannabis market begins in July 2027. Virginia previously tightened its hemp laws in 2023 through Senate Bill 903. That legislation followed concerns about children consuming edibles they believed were ordinary candy, as well as reports of people becoming more intoxicated than they expected. The law introduced child-resistant packaging, independent laboratory testing, clearer labels, potency limits, and required product reformulations. It also established a ratio requiring 25 parts CBD for every 1 part THC. State Senator Lashrex Aird said closing what she described as a loophole in that ratio does not prevent farmers from growing industrial hemp or producing items that comply with Virginia's 2 milligram THC limit. She said the objective is to prevent intoxicating products from being sold as hemp outside a more tightly controlled cannabis system. Hemp operators respond that their businesses are already regulated. They are also concerned that the new recreational market may favor larger cannabis companies over Virginia farmers and small retailers. For consumers, the immediate question is whether familiar hemp products will remain available. For operators, the question is whether they can stay in business long enough to participate in Virginia's next cannabis market.
While Texas and Virginia debate restrictions and regulatory boundaries, Illinois is expanding several parts of its established cannabis system. The Illinois Department of Financial and Professional Regulation has issued guidance explaining how licensed dispensaries should implement SB 3222. Governor J.B. Pritzker signed the broader cannabis and hemp reform measure into law. The new rules immediately double the amount of cannabis that adults may legally possess. Illinois residents aged 21 and older may now possess up to 60 grams of cannabis flower, 10 grams of cannabis concentrates, and infused products containing as much as 1,000 milligrams of THC. The legal possession limits for visitors from outside Illinois have also doubled. Consumers may soon see new ways to collect their purchases. Licensed dispensaries may offer drive-thru service and curbside pickup after receiving regulatory approval for their systems. Dispensaries may also remain open until 2 a.m., when the local government allows extended operating hours. The law expands benefits for registered medical cannabis patients as well. Patients may now purchase cannabis seeds, and additional medical conditions qualify for the state program. Beginning September 10th, adult use dispensaries that remain in good standing may apply for medical cannabis licenses. Approved locations would then be able to sell products to registered patients at the lower medical tax rate. For cannabis businesses, the legislation also changes security requirements, employee licensing rules, product labeling standards, and ownership eligibility. Additional regulations are expected as implementation continues. Broader provisions under the Illinois Hemp Act are scheduled to take effect later this year. Illinois is continuing to refine its cannabis framework as its legal market matures.
Kentucky's medical cannabis program is operating, but some patients say legal products remain financially out of reach. On July 1st, Governor Andy Beshear lifted a 2022 executive order that had protected qualified Kentucky patients from prosecution when they traveled to another state to purchase medical cannabis. Patients are now expected to buy their medical products within the Commonwealth. At a recent meeting of the Interim Joint Committee on Agriculture, 60-year-old Ricky Hunt of Hopkinsville described what that change means for him. Hunt said he has experienced severe pain since surviving spinal cord cancer as a child. He testified that a 1-gram THC vape cartridge available in Metropolis, Illinois for $24 was priced at $130 at a Kentucky dispensary. Medical insurance does not cover medical cannabis. Patients must pay the full cost themselves. Kentucky data places average retail prices at approximately $40 per unit for edibles and more than $100 for some vape products. State officials say the age and size of Kentucky's market are contributing to those prices. Dispensaries have been operating only since late 2025, with legal sales beginning in December. 17 dispensaries are currently open statewide. Kentucky also limits its medical cannabis program to 16 cultivators and 10 processors. Total cultivation space is capped at 115,000 square feet across the state. Sam Flynn, Deputy General Counsel at the Kentucky Office of Medical Cannabis, told lawmakers that surrounding states have more mature markets and produce larger quantities of cannabis. Greater production generally contributes to lower consumer prices. Flynn said Kentucky prices should decline as additional cultivation and processing capacity becomes available. Industry advocates are asking lawmakers to consider further changes. Their proposals include allowing telehealth appointments, giving physicians broader discretion, removing the notary requirement, and relaxing restrictions on advertising. Kentucky patients now have legal access to medical cannabis, but affordability remains a substantial barrier.
The cost of medical cannabis is also driving a political dispute in New Hampshire. Governor Kelly Ayotte has vetoed Senate Bill 468, which would have allowed alternative treatment centers to cultivate medical cannabis in greenhouses. The proposal passed both chambers of the New Hampshire legislature by voice vote. It would have allowed licensed medical cannabis providers to seek authorization for greenhouse cultivation at an existing cultivation property or at a separate location. Supporters said greenhouses could reduce energy expenses and help lower prices for registered patients. The measure included several conditions. State regulators would have established security and location requirements for greenhouse operations. Applicants would have been required to submit plans explaining how the cultivation method would save money and reduce patient prices. Local zoning restrictions would still have applied. Regulators would also have gathered input from patients, caregivers, and nearby residents before approving a greenhouse site. Governor Ayotte vetoed the legislation, saying she does not support expanding marijuana cultivation in New Hampshire. Supporters are now asking the legislature to override her decision. Republican State Senator Howard Pearl, the bill's lead sponsor, said the proposal would have reduced costs for patients with serious medical conditions while preserving regulatory safeguards. Democratic State Senator Tara Reardon said the veto blocks a cost-saving measure for more than 17,000 veterans and other patients who rely on medical cannabis. Cindy Warmington, the Democratic candidate seeking to challenge Ayotte, also criticized the veto. She said greenhouse cultivation would have made medical cannabis more affordable and accessible. New Hampshire considered a similar measure in 2024. Then Governor Chris Sununu vetoed that legislation. The State House had enough votes to override him, but the Senate did not. New Hampshire's medical cannabis cultivation rules remain unchanged. The next question is whether lawmakers can assemble enough votes to override Ayott's veto.
In Kansas, marijuana remains completely illegal, and legalization is emerging as a visible issue in the race for governor. Democratic State Senator Cindy Holscher released a campaign video from the parking lot of a Missouri dispensary near the Kansas border. She said the parking lot was filled with vehicles carrying Kansas license plates and argued that cannabis tax revenue is leaving Kansas for Missouri. Holscher said Missouri collected $255 million in cannabis taxes last year. She argued that Kansas could use comparable revenue for schools and public services if it legalized marijuana. Another Democratic candidate, State Senator Ethan Corson, supports legalizing both medical and recreational cannabis. Corson said Kansas is falling behind, while residents with chronic pain, post-traumatic stress disorder, cancer, and other serious conditions remain unable to obtain legal cannabis. He said legalization should include public safety guardrails while respecting personal freedom and generating revenue for the state. Overland Park Mayor Kurt Skoog is taking a more limited position. Skoog said one of his first actions as governor would be to ask his running mate, physician Jennifer Bacani McKinney, to help develop a medical marijuana plan. He said he could potentially support recreational legalization at a later stage, but wants a regulatory structure in place first. The leading Republican candidates largely remain opposed to legalization. None currently supports legal marijuana for medical or recreational purposes, although candidate Nick Reinecker supports decriminalization. Polling indicates that cannabis reform has majority support among Kansas residents. One Kansas Speaks poll found that 70% of respondents supported medical marijuana, and 60% supported legal adult use. Another survey found 70.4% support for medical cannabis and 64.8% support for recreational legalization. Cannabis remains illegal in Kansas, but the governor's race has made clear that the issue will remain part of the state's political debate.
Kansas voters may be considering whether their state should move toward legalization. In Massachusetts, voters could be asked whether an established recreational market should move in the opposite direction. The Massachusetts Elections Division has certified that organizers submitted enough signatures to place a cannabis rollback proposal on the November 3, 2026 ballot. Organizers needed 12,429 valid signatures in the final collection round. They submitted 12,551, exceeding the requirement by 122. The proposal would not make marijuana possession illegal. It would instead repeal the state laws permitting regulated recreational cannabis sales and adult home cultivation. Massachusetts' medical marijuana system would remain in operation. The ballot measure still faces a formal challenge. Kevin Gilnack, who leads a cannabis advocacy organization, has filed an objection with the State Ballot Law Commission. He argues that some signatures should be excluded because they were allegedly collected through fraudulent practices, were submitted by people who later asked to have their names removed, or contained formatting and other problems. The commission is scheduled to hold a hearing on July 15th. The measure has already survived earlier challenges. Previous objections alleged that voters had been misled by the petition materials. The State Ballot Law Commission rejected an earlier challenge. The Massachusetts Supreme Judicial Court also allowed the proposal to proceed after opponents argued that it presented constitutional problems. The signature-gathering campaign has faced additional scrutiny. In June, the Coalition for a Healthy Massachusetts said it dismissed a signature gatherer after a video appeared to show misleading arguments being used to persuade voters to sign. Cannabis business leaders, healthcare professionals, and legalization advocates have launched a campaign to defeat the proposal. Massachusetts voters approved recreational marijuana legalization in 2016. Since then, the adult use industry has generated billions of dollars in sales and tax revenue. The proposal is currently certified for the November ballot, but the July 15th hearing could determine whether it remains there.
A federal lawsuit in Pennsylvania is bringing marijuana convictions and gun rights into the same case. Craig Phillips of Butler County has filed the lawsuit with Gun Owners of America and the Gun Owners Foundation. The defendants are Pennsylvania State Police Acting Commissioner Lieutenant Colonel George Bivens and Butler County Sheriff Michael Sloop. The lawsuit challenges a Pennsylvania law that denies a license to carry firearms to people convicted of offenses under the state's drug laws. Phillips served in the United States Air Force from 1989 until 1992 and received an honorable discharge. In 1994, he was convicted of possessing a small amount of marijuana. The lawsuit says Phillips has not used marijuana or other unlawful drugs since that conviction. It also says he has no other criminal convictions and may legally own and possess firearms. Phillips applied for a Pennsylvania carry license in Butler County in 2024. His application was denied because of the marijuana conviction from 30 years earlier. The complaint says that denial restricts his ability to carry or transport a firearm in a vehicle, carry a firearm in Philadelphia, carry during a declared state of emergency, and bear arms in public for lawful self-defense. The lawsuit points to recent United States Supreme Court decisions expanding gun rights, including a case involving marijuana use. The complaint argues that regular marijuana use does not, without additional evidence, automatically establish that a person is violent or dangerous. Phillips' attorneys contend that Pennsylvania cannot permanently deny him a carry license because of a single, non-violent marijuana conviction from more than 3 decades ago, when there is no current evidence that he presents a danger. The case does not challenge carry license restrictions based on felony convictions. It focuses on otherwise eligible applicants who are denied licenses because of minor marijuana offenses. The outcome may affect other Pennsylvania residents with old cannabis records, as courts continue to consider how past marijuana conduct intersects with modern firearm rights.
Wyoming is declining to follow the federal government's latest marijuana rescheduling action. Attorney General Keith Couts said Tuesday that marijuana will remain a Schedule I substance under the Wyoming Controlled Substances Act. His decision follows federal action by the Trump Justice Department, moving certain state-licensed medical marijuana products, together with cannabis medicines approved by the Food and Drug Administration, from Schedule I to Schedule III under federal law. Wyoming law generally provides that when the federal government reschedules a substance, the state should apply the same classification within 30 days. The law also permits the State Commissioner of Drugs and Substances Control to object. In Wyoming, the Attorney General holds that role. Couts exercised that authority and objected to the federal change. He held a public hearing in June and accepted written comments. 4 email submissions supported keeping marijuana in Schedule I. 4 supported moving either marijuana generally or medical marijuana to Schedule III. 1 person testified in person and asked that all marijuana remain classified as Schedule I. Couts said the Wyoming legislature has not legalized medical marijuana, created a state-licensed medical cannabis system, or recognized medical marijuana identification cards issued by other states. He concluded that any decision to remove marijuana from Schedule I in Wyoming should be made by lawmakers rather than through an administrative change. The practical result is that Wyoming still has neither legal medical cannabis access nor a recreational marijuana market. Cannabis businesses receive no new state-level pathway from the federal action. Patients who hoped federal rescheduling would provide access to medical cannabis in Wyoming will still need the legislature to act. Wyoming lawmakers have previously considered proposals involving decriminalization and adult use legalization, but none has become law. Marijuana will remain a Schedule I substance in Wyoming unless the legislature changes the state's policy.
The divide between federal and state cannabis laws is also renewing pressure on Congress to address banking access. The American Bankers Association has sent congressional leaders a letter urging passage of the Safe Banking Act of 2026. The bipartisan legislation was reintroduced last month in both the House and Senate as Senate Bill 4942 and House Resolution 9471. Marijuana remains illegal under federal law, even though nearly every state has legalized cannabis in some form. Because of that conflict, many banks remain unwilling to work with cannabis companies, including businesses operating legally under state law. As a result, some licensed cannabis operators continue to handle large quantities of cash. The American Bankers Association says the current system creates risks for businesses, financial institutions, employees, customers, and surrounding communities. It argues that the Safe Banking Act would move more cannabis revenue into the regulated financial system, reduce the amount of cash stored at business locations, and improve public safety. The bill would prevent federal regulators from penalizing banks solely because they provide services to state legal cannabis companies. It would also establish protections from criminal prosecution and asset forfeiture for participating banks and their employees. Some protections would extend to businesses and professionals that provide services to the cannabis industry, including lawyers, landlords, and vendors. The bill would not resolve every federal financial issue affecting cannabis businesses. It would not change Section 280E of the Federal Tax Code. Banks would also remain responsible for filing suspicious activity reports involving cannabis-related transactions. Cannabis industry executives support the proposal. They argue that reliable banking access would allow legal operators to manage capital, make investments, and conduct business more like companies in other regulated industries. Congress has considered cannabis banking legislation several times. Versions of the proposal have passed the House of Representatives 7 times. A cannabis banking measure also advanced through the Senate Banking Committee in 2023. None of those efforts became law. The American Bankers Association says federal marijuana rescheduling and changing hemp regulations have made congressional action more urgent. The unresolved question is whether the latest version of the Safe Banking Act can finally pass both chambers and reach the president.
That concludes this week's Cannabis News Briefing. This program is released every Saturday at 9 a.m. Subscribe on your preferred podcast platform or YouTube to receive the next edition. If you are already subscribed, hit the like button, leave a rating or comment, and share the program with anyone following cannabis policy in the United States. Thank you for listening.